All right, welcome back to another Explainer. Today, we're diving into a really fascinating slice of South African legal history. We're looking at Case CCT 10/02. Now, this is a 2002 dispute, mostly between the South African Municipal Workers Union and the City of Cape Town. But you know what makes this case absolutely captivating? Isn't actually the original disagreement. It's the incredibly bold procedural chess move the union tried to pull off in the aftermath. It's a real legal wildcard.
And that brings us to the central mystery we're unpacking today. Can you just skip the line to the highest court in the land? Because usually, when you're locked in a massive legal battle, standard procedure says you climb the judicial ladder one single rung at a time. But here, the union attempted a massive leap. They tried to completely bypass standard procedures to get a final answer straight from the Constitutional Court. So we're going to explore exactly how they tried this and, well, whether or not it actually worked.
Okay, let's dive into this. Section 1. The initial police dispute.
Every great legal battle has a spark, right? And we really need to understand what ignited this one before we can appreciate the union's legal strategy. So the heavy hitters here include the applicant, which is the South African Municipal Workers Union, and their main target, the first respondent, the City of Cape Town. But definitely take a look at the other respondents involved here. We've got the provincial government, the Minister of Safety and Security, and even the National Commissioner of Police. I mean, this is a major structural dispute. The whole conflict caught fire when Cape Town decided to establish a brand new municipal police force. The catch? They made this massive institutional change without actually consulting the union first. So, feeling totally sidelined, the union took the city straight to the High Court to try and get that decision set aside.
Let's map out exactly how this procedural journey played out. It all starts with that initial incident, right? The city's decision without consultation. The union challenges it in the High Court, but they face a pretty huge setback. They lose. The High Court absolutely refuses to set the city's decision aside. But here is where things get super interesting. Instead of just accepting defeat, the union makes this highly strategic move. They apply for a direct appeal. And that ambitious move sets the stage for the final word on this entire procedural maneuver, the Constitutional Court judgment that came down on May 9, 2002.
Section 2. The High Court's mixed signals.
So the union lost round 1. Now, to keep fighting, they needed what's called a Rule 18 certificate, which is basically part of the Constitutional Court's rules for appealing. But now, what's really interesting about this slide is the glaring contradiction in the High Court's response. It literally puzzled everyone. On one hand, they flatly stated there was no constitutional matter of substance involved, and that it wasn't in the interests of justice to go directly to the Constitutional Court. I mean, that sounds like a total shutdown, doesn't it? But then, in the exact same breath, the High Court certified that there's a reasonable prospect the Constitutional Court would actually reach a different conclusion than they did, and they added that there was sufficient evidence on the record to just settle the matter right then and there. Talk about a mixed signal.
But, to be fair, the High Court didn't just leave them totally hanging with that confusing certificate. They gave them a safety net. The High Court also granted the union leave to appeal to the Supreme Court of Appeal. So this was essentially their backup plan. If the Constitutional Court slammed the door on a direct route, the union still had the traditional, everyday legal route open to them.
Section 3. Attempting the legal shortcut.
The thing is, the union really didn't want the traditional route. They wanted a resolution, and they wanted it from the absolute highest authority right away. It helps to think of the legal system like a giant ladder. Step 1 is the High Court, where the union originally lost. The normal, expected progression is to climb up to Step 2, the Supreme Court of Appeal. And then, only after that, if you still have constitutional issues, do you climb to Step 3, the Constitutional Court. So this direct appeal the union was trying, it was an incredibly ambitious leap. They were trying to jump straight from Step 1, completely hurdle over Step 2, and land perfectly on Step 3.
And just to make sure we're all literally on the same page, the legal mechanism the union was using to attempt this massive jump is called leave to appeal. Very simply, it's the formal permission granted by a court that allows a party to challenge a ruling in a higher court. So the union was formally asking the Constitutional Court for this exact permission, begging them to open the door to Step 3 without forcing them to trudge through Step 2 first.
Section 4. Statutory versus constitutional interpretation.
So now we're at the top step. Acting as the ultimate gatekeepers, Chief Justice Chaskelson, along with 10 other judges, had to decide if they were going to allow this shortcut. And here is their definitive legal anchor, straight from the judge's decision. They stated, "This is a matter in the first instance concerning the interpretation of a statute rather than the interpretation of a constitutional provision." And honestly, this is the absolute core reason why the shortcut was denied. The court is essentially saying, look, before we can even begin to talk about broad constitutional rights, we first have to figure out exactly what the everyday laws, the specific statutes governing municipalities and police forces, actually mean. Because this entire case fundamentally boiled down to reading and interpreting a regular, everyday statute, the Constitutional Court decided it totally failed the interests of justice test for a direct appeal. There were just no compelling reasons to skip the Supreme Court of Appeal. After all, the Supreme Court of Appeal is perfectly equipped, literally designed actually, to handle complex matters of statutory interpretation. So jumping right over them just didn't make any legal or procedural sense here.
So the crucial point to take away from this is a really important nuance. While the Constitutional Court did reject the direct appeal, they explicitly refused to confirm the High Court's earlier, super confusing finding. Remember how the High Court claimed there was no constitutional matter of substance? The Constitutional Court completely refuses to endorse that. They aren't saying the union's case lacks constitutional weight whatsoever. They're just saying, hey, it's not our turn yet. Go do your time at the Supreme Court of Appeal first.
Section 5. The final verdict. And this all brings us to the final resolution of this specific crazy procedural chapter. The unanimous judgment handed down by all 11 justices on May 9, 2002 was incredibly structured and crystal clear. First up, the application for leave to appeal directly to the Constitutional Court. Officially refused. The shortcut is firmly closed. Second, they spell out the exact next step. This matter has to be heard by the Supreme Court of Appeal using that backup plan the High Court originally granted. And finally, the financial impact. The court ruled that costs to be costs in the appeal to the Supreme Court of Appeal.
Now you might be wondering, why on earth did they structure the legal costs that way? Usually, if you try a super bold maneuver in court and you lose, you get slammed with the other side's legal bills right on the spot. But check out this fascinating detail. The highest court actually offered a silver lining. They wrote, "We do not think it was unreasonable for the applicants to have approached this court. Even though the union got rejected and literally sent down a rung on the judicial ladder, the Constitutional Court didn't financially punish them for trying it. They fully acknowledged that given how complex the case was and those crazy mixed signals from the High Court, trying the shortcut was a completely reasonable move. So the costs just get rolled into whatever happens next." Which of course leaves us at the end of this procedural detour, staring at the ultimate cliffhanger. The Constitutional Court firmly pointed the way to step 2 of the ladder. The shortcut was a no-go, but this huge battle over the Cape Town Municipal Police Force, it is far from over. It forces us to ask one massive question. How will the Supreme Court of Appeal ultimately interpret that statute? Well, that, my friends, is a legal battle for another day. Thank you so much for joining me on this explainer, and as always, keep questioning the process.